This video is for educational purposes. It is not legal advice. Some content was created with the help of AI.
Welcome. In this video, we're exploring the discovery process in civil litigation. Discovery is the stage where parties exchange information before trial, so both sides know the evidence and can prepare fairly. Think of discovery as a set of tools. A builder uses a drill or a wrench to get the job done. Lawyers also use tools, but their tools are for discovery. These tools help gather facts. They narrow the issues. They help build the case. Discovery shines a light on the facts, no surprises, only preparation. Discovery is a formal process. Each party can request and exchange information. The purpose is simple: to avoid trial by ambush, to narrow down the issues, and to encourage settlement before trial.
The pleading stage is over. This discovery begins.
After the pleadings are complete, the case is ready to move forward. This means the complaint and the answer are filed. In most systems, discovery begins after the court issues a scheduling order. This usually happens at an initial case management or scheduling conference. Each jurisdiction has its own rules and procedures. But in general, discovery starts once the pleadings are closed and the court sets the timeline. Discovery is limited in time. It must be completed by a specific date before trial. This is called the discovery cutoff. It is important to calendar this period carefully. You need to know how much time you have and when it ends. Different tools are available to gather information. The most common discovery tools are interrogatories, requests for production, requests for admission, depositions, and subpoenas. Each jurisdiction has its own rules for discovery. These rules cover the number of requests allowed, the timelines for responses, and the proper grounds for objections. There are also other procedural requirements. It is important to check the rules in your own jurisdiction. This helps you understand the framework. It also makes sure your discovery is effective and compliant. Interrogatories are written questions one party sends to another. They must be answered in writing, usually under oath. They're used to get background information like names of witnesses, timelines, or factual details. Check the rules in your specific jurisdiction regarding the number of interrogatories, timelines, and other procedural requirements. The following are common requirements recognized in most jurisdictions. First, requests should be reasonably calculated to obtain information that is related to admissible evidence. Second, requests must not be overly broad or require an unreasonable amount of effort to respond. Third, do not seek information protected by recognized privileges such as attorney-client or work product. Next, requests must comply with constitutional and statutory privacy rights. Finally, interrogatories must be clear with well-defined terms and unambiguous language. Each interrogatory should ask a single question. Avoid combining multiple questions into one. Another important discovery tool is the request for production. A request for production is a formal legal tool used in civil discovery to obtain documents, electronically stored information, or tangible items from another party. It allows parties to gather evidence they need to build their case. The responding party must provide a written response and produce the requested items within a certain time period. The exact deadlines, scope, and other procedural requirements vary by jurisdiction, so it's important to check the rules in your jurisdiction. Requests for admission are written requests in the legal discovery process asking the opposing party to admit or deny certain facts or the authenticity of specific documents. The purpose of requests for admission is to streamline lawsuits by resolving certain issues before trial, potentially saving time and resources. Key purposes of requests for admission include: first, requests for admission help parties agree on basic facts, reducing the need to prove those facts at trial. Second, they simplify the trial by allowing certain evidence, such as the genuineness of documents, to be taken as true. Finally, admitted facts can support a motion for summary judgment by showing no material issues of fact remain. Each jurisdiction has its own rules regarding the number of requests, deadlines, and other procedural requirements, so it is important to check the rules in your specific jurisdiction. Requests for admission should not demand legal conclusions, case strategy, or reasoning. Requests should not be compound, meaning they should not combine multiple distinct inquiries in a single request. If a party does not respond, the court may treat all facts as admitted and all documents as genuine. A deposition is a formal, pre-trial legal proceeding where a witness or party provides sworn, out-of-court testimony under questioning by opposing attorneys. A deposition is part of discovery. It gathers facts, it tests credibility. It helps lawyers prepare for trial. The witness takes an oath. The setting is outside the courtroom. A court reporter records everything. Attorneys ask questions to gather facts. Depositions are used to learn the case, to challenge credibility, and to provide evidence at trial or motions. Depositions are complex, they need preparation, they are costly. You must pay a court reporter. You must cover logistics. Attorney fees add more cost. A subpoena is a formal request designed to obtain information or testimony from a non-party to a case. Remember, subpoenas are mainly for non-parties. Discovery requests for parties use other tools. A subpoena can be issued by a court or an attorney. It must be personally served. The purpose of a subpoena is clear. First, to compel testimony. Second, to require documents or evidence. Third, to gather information needed for a fair case. There are three main types of subpoenas. The first requires a person to appear and give testimony. The second requires a person to produce documents or records. The third is a combined subpoena that requires both testimony and documents. In some places, subpoenas, like for consumer records, need prior notice. This allows the person to object before records are given. Watch our separate video to see the step-by-step process for filling out a California subpoena.
If you enjoyed this video, please like and subscribe. It helps us create more content for you.